Lil Durk's lawyers have filed a motion to sever counts, or in the alternative, to dismiss the third superseding indictment. Lil Durk has wanted to go to trial as soon as possible for the last year and a half, but it's been delayed constantly over his objection. Since the government added a bunch of new charges in other states, his lawyers are now asking to sever those counts so they can start the trial in August for the LA murder. His lawyers are pissed. They're saying this was all intentional, and they want to go to trial as soon as possible. All right, here we go. We got Drew Findling, Brian Steele, Christy O'Connor. I always forget Durk got some crazy good lawyers, bro. Defendant Durk banks through his attorneys Drew Findling, Marissa, Brian Steele, Christy. Hereby files this motion to sever counts 1 and 6 from counts 2, 3, 4, and 5, the LA counts of the third superseding indictment. This severance is necessary so that Banks might have the August 20th, 2026 trial that he has been preparing for since October of 2024, and that the Sixth Amendment speedy trial provision guarantees him. Prosecutors filed that superseding indictment, adding a bunch of crimes from Chicago and Atlanta and a bunch of other states, right? The LA murder has been in there since the beginning. His lawyers are saying we want to go to trial just for the LA counts in August, like we're scheduled to do so, because it's going to get pushed back if they don't.
I didn't even realize he got arrested in October 24, nigga. It's going to be 2 years, bro. See, when you outside of life, when you in the real life, time go by fast. I bet you it feel like he been in that bit. Go ask him. He probably say, I feel like it's only been 2 years. I feel like it's been like 5 years. It's crazy. Like, free me. Like, I'm not a gangster anymore, please.
Should court deny Mr. Banks' motion to sever counts, the inevitable delay in this trial date caused by the government's unreasonable 11th hour addition of significant new allegations requires dismissal of the indictment, which makes sense. Durk hasn't waived his right to a speedy trial. He wants a speedy trial. He's been asking for it. The delays have largely resulted from the case being designated as complex under the Federal Speedy Trial Act, the number of defendants, extensive discovery and scheduling issues involving co-defendants, not because Durk waived his rights. For 19 months, Mr. Banks and his defense team have been preparing to defend against charges related to the August 2022 killing of SR in LA. Team Banks is prepared to proceed on those charges on August 20th as currently scheduled. This trial date that had been continued 3 times over Mr. Banks' objection, had his demand for a speedy trial carried the day, he would have had his day in court in October of last year, and right now he would be home with his family. Confidence. They're like, if this would have happened 8 months ago or whatever, he would be home right now. But alas, really? Mr. Banks did not receive the timely trial he demanded. And so, in the interim, the defense team continued its preparations in earnest, preparations based on government representations about the intended scope of its case and court rulings addressing the same. These efforts have included actively litigating the admissibility of 1. Regarding evidence of other bad acts, including the January 2022 killing of Stefan Mack in Chicago, quote-unquote, the Chicago incident. 2. Certain of Mr. Banks' song lyrics. After multiple rounds of briefing and argument, the court tailored a carefully considered ruling on the lyric issue. After representing to the court in January that the United States Attorney's Office had turned over all discovery related to the Chicago murder, it had not. The government announced in February that it was taking the Chicago incident off the table. The defense and the court proceeded for months in reliance on that representation, along with an array of the other government representations about what other bad act evidence it would and would not seek to introduce at trial. So they're saying pretty much the state attorney's office has lied, specifically about the Chicago murder of Stefan Mack. They said they weren't going to include that in the indictment, and then they ended up doing it anyway. So they did lie, low key. The government now.
Listen, y'all, YouTube and Meta might owe you up to $1,000 if you or your child grew up on social media. If you or your child spent years growing up on social media and experienced serious mental health issues, you should hear this. Recently, a jury just ordered Meta and YouTube to pay millions for their role in designing and promoting addictive platforms. They know that their apps can cause anxiety, depression, or body image issues, but they never shared those risks with us. They never made us sign anything that we knew the risk. They just maximized their profits. And the recent historic verdict underscores the consequences of those decisions. But you better not worry. Morgan & Morgan is stepping up to hold these platforms accountable for the harm that they have caused. Click the link in my bio to take a very short questionnaire quiz, because you might be entitled to a potential recovery of over $1,000.
Attempts to undo all that the parties in the court have worked for. Less than
Lil
3
Durk
months
lied
before
too. Lil Durk said he didn't have nothing to do with it, and he do.
trial, it supersedes for a 3rd time, reinserting the Chicago incident into the playing field and adding inflammatory accusations it could have charged from the start, including an alleged attempted murder in Atlanta in 2019, the Atlanta incident, robbery, theft, and a multi-state drug trafficking operation. Further, the government now asserts that because it has superseded for a 3rd time, all prior litigation on the music emissions has been naught.
The hell that mean?
What? They want to relitigate all the lyric shit? This is so grimy. They're trying to undo what has already been litigated. In 2 successful news supplemental notices, 37 and 40 pages long.
What? What's grimy is going to kill somebody in cold blood. That's grimy. What's grimy is flying to LA and setting up murders. What's grimy is paying money for a nigga to kill somebody because that's grimy. Bro, they trying to lock up a killer. So I don't understand. And it's like everybody, y'all know damn well that this man did that, bro. Y'all know this man did that. He said he did it. What's grimy about the police trying to lock up a nigga who said that he killed people?
Respectively, it reserves the right to seek the omission of a significant amount of previously unnoticed music lyrics and videos. Regardless of whether this government gamemanship and effectiveness or something else altogether, what the government is doing here imperils the constitutional rights of a man who is presumed innocent but nevertheless languishes in jail. In situations like this, where a defendant would otherwise suffer such prejudice to a fundamental right, the law affords this court wide discretion to order separate trials of counts contained in the same indictment, and they cite the law. Mr. Banks requests that this court permit him to proceed to trial on the LA counts against which he has been working so hard to prepare a defense. And the alternative, if Mr. Banks is forced to defend against additional serious charges that the government could have, with due diligence, brought in the first instance, the government has in essence forced a continuance. Mr. Banks' speedy trial rights would then demand a dismissal of this case. Defense is saying the prosecution waited too long to add all these charges and shit, and they should have did it off rip. This case has been taking shape for almost 19 months. June 21st, 2023, the government is aware of redacted allegation that Mr. Banks funds OTF drug trafficking. October 17, 2024, the government issues its first indictment in the case. Kayvon Grant is the lead defendant. Mr. Banks is not charged yet. October 24th, Mr. Banks is charged by complaint and taken into custody. He has remained in custody ever since, including almost 5 months in segregated housing. Oh yeah, he was in like the SHU, I think, for months. Forgot about that. December 2024, the government raises the Chicago incident in its brief in support of detention. The brief cites a search warrant affidavit from Northern District of Illinois for the proposition of that Mr. Banks offered money for people to kill those responsible. The government gives him a batch of discovery in December 2024. Banks has been involved in criminal activity, including the shooting outside of Atlanta restaurant in February 2019, where they were shot multiple times. Fonnie Willis in Atlanta, it was a state case, dropped those charges. Some people commented the feds probably asked him to drop those charges. I don't think it was that. In fact, his lawyers even just said the federal case started happening in 2023 at some point. But that does happen where state cases get dropped because the feds are like, yo, we're already investigating this. You don't have to do it. Happened in the Epstein case. Like that property that Epstein had. Sorry, off topic. Trial gets set for October 2025. Mr. Banks moves to dismiss the first superseding indictment based on the government's presentation of false evidence to the grand jury. The government told the grand jury that lyrics contained in the song Wonderful Wayne and Jackie Boy constituted an after-the-fact commercialization of SR's death, in which Mr. Banks raps about his revenge on Quando Rondo.
Yep.
With the music that explicitly referenced audio from a news clip taken shortly after SR's murder. The government's read on these lyrics, however, is demonstrably false. The song was recorded 7 months before SR was shot and killed, and thus could not be commercialization of his murder. Yeah, they pretty much proved that wrong, and the government was like, oh shit, they're probably right, and just like dropped it. All counts in the second superseding indictment pertain to the August 22 LA shooting. The second superseding indictment removes the false allegation contained in the first about the meaning of his lyrics. Government sends a 404B notice about more songs. Aha, rumors scoom his ass. Mr. Banks does not join the government, and co-defense stipulation to continue trial from October to January, although it's granted over his objection, so delayed again 3 more months. When I saw the October date, I was like, that shit's getting delayed. Now his co-defendants start filing that they want to be severed from Durk. His co-defendants citing the spillover prejudice from evidence primarily concerns Mr. Banks, including the Chicago incident and proposed song lyrics. Then they point out in October his trial should have started here and he would have received a speedy trial, but he didn't. His lawyers then request all discovery from the Chicago incident. The person who's referred to as co-conspirator 6 passes away. So who they're talking about is Bezu here. He passed away last year. He was shot and killed in Chicago, and they were friends for years. Like,
yeah.
I'm pretty sure they were like best friends. Like, look at this old ass picture of them together. I mean, this is from at least 2012 or 2014, probably 2014, I think. It had lyrics from Who Wants Smoke, Go, and Block Is Hot. No music videos. But he cites these songs as admissions. It's crazy, right? Lyrics are admissions in court. I've stated my opinion on this. Lyrics must have a nexus. If someone gets shot by like a Glock switch and a Escalade, and then someone goes and raps about shooting someone with a Glock switch into an Escalade, then you can add it. But if the lyrics are vague about just shooting enemies and ops and shit, you can't add it, motherfucker. Now we're getting a little bit
I don't see why not. You know what I mean? If you don't think they're gonna bring up lyrics that Pooh Shiesty did, is he's on video murdering people, and I mean not murdering, he's on video shooting people and robbing people. So his lyrics are not going to help him. Maybe they might not use it as direct evidence, but they damn sure ain't gonna help. I tell you that. What the hell? What do y'all expect? That's my question. Like, what do you genuinely expect? Like, you think you're just gonna be rapping about murder? What am I supposed to think, bro? What am I supposed to think? If you rapping about murders, killings, shootings, robberies, deaths, hits, selling drugs, and then you get caught with 1,000 bricks, 10 guns, and you get caught on video shooting somebody, I'm going to use those lyrics, bro. What the hell? Young Thug said we shot at his mommy. They shot at his mama. What are we talking about?
Of a transcript from January here from a hearing. At the hearing, it asked the government whether it has provided the defense with both the notices of incidents, which would be considered 404B evidence. I think they're quoting the judge here, but what I want to ask the government is, I don't want this to be a moving target. Is there any doubt of this right now that the evidence related to 404B has been provided, that the incidents which listed in the motion and limine are like 10 different incidents that are disputed? Has all that been disclosed? In response, government counsel represents that everything that the U.S. Attorney's Office has in connection with different events and 404B evidence has been produced, has been disclosed. Durk's lawyers take issue with that. The court reiterates, and in the meantime, I want the government to make sure that it's providing everything it currently has. That's what these prosecutors always do, bro. In the YSL case, they try to hold evidence as long as they can. I swear that shit's intentional. More songs, Hanging with Wolves, Block is Hot, blah, blah, blah. Judge is quoted saying, I'm not addressing here a number of things that the government originally put forth in the notice because I would say based on the reply, the government's memoranda, that the government does not intend to offer several of those things. So in that sense, I think the government is much more given up on a number of points. The government does not correct or dispute the court's understanding. At the hearing, after the court expressed doubt that the evidence in the Chicago incident would be admissible, the government told the court they would not seek to admit it. They represented, we are not inclined at this time to introduce the evidence, so I think we're going to make an easy issue. Damn. Okay, so that's about the whole Chicago murder that they ended up adding in June. The judge was like, I don't think they're going to add it anyway, and then the government agreed with them. But then they added it. The judge is also quoted saying, as an initial matter, the government initially indicated that it intended to introduce evidence surrounding an incident that occurred in 2022 in Chicago. At the hearing, the government withdrew the evidence for consideration. The court also expressed its tentative view based on the briefing that it was inadmissible under Rule 44B or 43. The motion, therefore, is denied as moot as to the requested evidence. References to that incident will not be admissible without first obtaining the express permission of the court. The order goes on to address Mr. Banks' argument that the notice lacks the requisite specificity, noting that the government cannot be said to be sandbagging the defense by switching its relevant theories too close to trial. The order then addresses each proposed piece of evidence in turn and makes a number of admissibility rulings. So the judge even said they were sandbagging the defense about that Chicago murder of Stephon Mack, adding that in last minute. Look at this quote. I think this is from the judge too. The severance motion certainly is not a trivial motion. However, obviously, it would have been considerably stronger had the Chicago evidence remained in the case. So the reason I haven't had a hearing on it yet, is because I wanted the record to be clear as to what additional evidence was going to be admitted and which was not. So the judge has already said on the record, a severance motion would be stronger with that Chicago case and the whole trial. And it's now in the whole trial. So a severance motion is strong in the court's eyes. February 10th, the government produces a discovery in the Atlanta incident. February 26th, the court denies Mr. Williams' motion to sever defendants based in part of the government's representation regarding the Chicago incident. It reiterated, as counsel no doubt realized, the motion was considerably stronger before the government's withdrawal of the Chicago incident. This is crazy. But the Chicago incident is back in there now. Things were ruled on because of the government saying they're not going to add the Chicago murder. Banks has not joined the government in the co-defense stipulation and continued the trial from April to August. So Durk has not been wanting any of these delays. The government sends a warning to the defense they're going to do another indictment by June 3rd. I read a whole document on that. May 29th, so a month ago, the government produced a large amount of discovery. In the face of an August 20 trial date, the government supersedes the indictment for a third time. Unlike the previous indictments, the third superseded indictment is not limited to August 22 LA incident. Instead, it alleges a sweeping racketeering enterprise that encompasses a broad array of previously uncharged or unnoticed conduct, including murder, attempted murder, robbery, theft, trafficking, and controlled substances, obstruction, attempted obstruction of justice, witness tampering. So they added a bunch of shit out of nowhere 2 months before trial, when it's already been a year and a half since Durk was arrested. It alleges that Mr. Banks funded a multi-state drug trafficking enterprise in order to secure Banks gang enterprise, quote unquote, associates' loyalty and ensure their willingness to engage in acts of violence. June 24th, so literally 5 days ago, the government amends its disclosure regarding music emissions. It communicates that it no longer intended to use any video associated with Go, although its intent to use the audio apparently remains. It also adds excerpts from 2 songs, Never Before Noticed, Computer Murders, and Sing This Song, quote unquote. Look at this funny ass note right here, frying them. This is probably because what the government represented to be the song's official music video was instead an amateur YouTuber's mishmash of unrelated video footage set to the song's audio. So remember that whole thing where
Yeah,
they
that
added
was
a
some,
piece
that
of
was
evidence
stupid.
about that song of news clippings and the audio?
Yeah,
So it
that was
sounded way
stupid.
worse. It made Durk look like he put news clippings of Quando Rondo screaming in his song when he didn't do that.
Yeah.
That's not what happened. It looked way worse. It's a fan edit. They put a fan edit in the indictment that wasn't made by Durk, and they called
But
it
you
the
know what
official
he-
music video.
You know what he did do in an official music video? He did show a clip, a comment that said "slide for Vaughn," and then it showed him killing somebody who just so happened to look like Quando Rondo. That's what he did do. So,
Court of Appeals are an explicit agreement. A superseding indictment does not operate to automatically restart the speedy trial clock. So what they're saying is every time the superseding indictment starts, it doesn't start that clock over. In federal case, it's 70 days. I'm pretty sure it's 70 days if I can recall correctly. The court has wide latitude to grant a Rule 14 severance where a defendant is prejudiced by a joinder. Unless the LA counts are severed at trial from the other counts, there's substantial risk that Banks' speedy trial rights would have been imperiled by the government's delay in seeking and producing discovery related to the third superseding indictment. The burden to justify the delay rests on the government. The defense, for its part, can think of no good reason for the unfortunate series of decisions the government has made that led us here. Take the treatment of the 2019 Atlanta incident. Although the incident has been squarely on the government's radar for the duration of this entire case, the government never even noticed its 404B, yet now, 19 months into Mr. Banks' confinement and prosecution less than 3 months before trial, the Atlanta incident is suddenly part of a common scheme with the LA incident. No doubt in its opposition of this motion, the government will argue that it's inseparable for the purpose of trial. Similarly perplexing is the government's treatment of the Chicago incident. When the government took the Chicago incident off the table in February, it had already considered whether the LA incident was a violent crimes in aid of racketeering murder. At least some of its agents believed that it was. When the government disavowed the Chicago incident February 26, it apparently did so for a tactical advantage in order to defeat Mr. Wilson's motion to sever defendants. What did I say earlier? Shit was denied to deny Dee Dee's motion to sever defendants. That's crazy. The government's tactical decision thus also has served to delay Mr. Banks' trial date over his objection. Further, whenever that the government began to contemplate the Chicago incident as part of the superseding charge, the government should provide the court with the answer. Why did it not then provide the full discovery that Mr. Banks had requested as far as back as October 17th? The defense is now in a position where it had to review, digest, investigate, and be prepared to review terabytes of new data just 2 months out from a trial in charge of carrying a life sentence. It is untenable. As for these incidents, along with the miscellaneous other allegations of the third superseding indictment, the defense has seen no blockbuster breakthroughs in the government's recent investigation that would justify the third superseding indictment's sandbaggery. Sandbaggery! In other words, the government had access to most, if not all, of the evidence supporting the racketeering murder counts months ago. It should be required to tell the court why it's not supersede then, and why Mr. Banks' trial date may potentially be disturbed as a result. He ejected the continuance from October to January, from January to April, April to August. Durkman objected to everything. If it is true as it appears to be, the government intentionally delayed these charges earlier than when it had the ability to. The law presumes even weightier prejudice than for negligent delay. So Durk's lawyers are pissed, rightfully so. They added all this shit last minute. Even though I do think it's damning evidence, some of it. Everyone deserves a right to a fair trial, and I think it's fucked up. So hit subscribe. Thanks for support. Peace out, boys.
if I find new evidence in a case that's as serious as this, I feel like they should be able to add that shit. Me personally. Now, if you talk about a pizza theft, it's okay, whatever. You know what I'm saying? But it's like, you can't just be adding shit to stall the case out. They can if they have evidence. That's the thing. They don't have evidence. Yes, they have, bro. They have some pretty serious evidence. Yeah, I don't know what people think is going to happen. Drew calling somebody else a liar is peak hypocrisy. Drew is a professional liar with a law degree. Drew is paid untold millions to lie for obviously guilty people. People like Durk Banks. No cap. Bro, are you like literally practicing lawyer in your everyday life? Your attention to detail is not going to work. Bombshell. I still think those charges were dropped because the feds asked them to. In 2000, that's what I think. I told y'all that a minute ago. I think the feds told the police, like, no, drop that shit. We got it. You know what I'm saying? Stephon Mack was killed in January. In February, AJ was arrested for a different case, and the police seized his phone and had text showing that he had the MDW. $1 million worth of game interview with Durk, and the ones between him and Marley talking about OTF paying them. The LA shooting happened in August, and Durk's charges in Georgia were dropped in October. I said this exact same thing like in one of my last videos. That would be too big of a coincidence for me. Edit. Also, if the feds weren't already on him, why would AJ and Marley be charged federally all the way in 2023 and not regular state murder charges for Stephon Mack? Especially considering they had AJ in jail and quite a bit of evidence to prove the murder already in the first half of 2022. Exactly. Why would the feds step in and charge them with that? Because that wasn't a federal crime. The actual murder themselves wasn't a federal crime. It became federal because it got communicated across different states. Otherwise, it would have just been a regular state case, state charge, regular state murder like anything else. Bro coming home for sure. Y'all delusional. I don't want any those look like Durk got the real dream team of lawyers. But who has they won? Like what cases has Drew Finland won? That's what I don't understand. What cases has Drew Finland like went in and just knocked them out the park? Like y'all niggas be paying all these millions of dollars for these lawyers that ain't really did shit. Deep down, we all know Durk did it. So it's like, what are we even talking about? Yeah. What are we talking about, bro? We know this nigga did this shit, bro. So it's like, come on, gang.